Judge.
Good morning.
Morning, my
May it
lady.
please the court, my lady. Morning.
Nelisiwe, may you please call the matter into the record?
Thank you, Judge. Today is the 9th of May, 2022. Calling the matter of Life Esidimeni Inquest, case number I-001 of 2021. Thank you, Judge.
Thank you. Yes, Ms. Marriott.
Thank you, my lady. The next witness was supposed to be Mavis Mokosinyana. It's Advocate Butlela's client. We've only been informed late Thursday after I've phoned Mrs. Mokosinyana to find out whether she will come to our office, that Advocate Butlela indicated that he's not ready to proceed with any of his client's evidence. He's also indicated there might be an application, but did not indicate what type of application he's going to bring today. So I would submit that he's the best person to address the court at this stage.
Mr. Patel.
Good morning, my lady.
Just before you proceed, I see there is a hand. Mr. Profi.
Very good morning. Apologies for interrupting before my learned colleague addresses the court. I'm just requesting to address the court after he goes, as I'm the one that wishes to address the court in respect of a certain aspect which impacts the next witness that's meant to be called. So once my learned friend has completed
the next witness is
Mavis.
Yes, you said you okay. Can we first listen to Mr. Patel? Mr. Pichela, you may proceed.
My lady, it is indeed correct that we had a conversation with Advocate Marriott regarding Ms. Mavis Mokosinyane. The matter which I referred to in cryptic terms is the one that
just a second. Can I think you are not that audible enough. Can I check with the others if they can hear you properly?
Apologies for that, man.
Can you hear him properly, if I may find out?
It's clear on my side, my lady.
Come again?
I can hear him, my lady.
Can you hear him? I was struggling. Okay, yes, continue, Mr. Pichel.
If your ladyship pleases. The matter which was being referred to is the matter that Advocate Profi wishes to bring to the attention of the court. Now, I would propose that he bring his application, as it has a bearing on whether or not my client, Mrs. Mavis Mokosinyane, should be testifying or not. Unfortunately,
but can we first hear you, because isn't it when we adjourn these proceedings, the arrangement was that you will liaise with the evidence leaders regarding when Mrs. Mokosinyane is going to testify. Am I correct?
That is correct, my lady.
Yes. I don't know.
Unfortunately, in that week, my lady, just maybe to put it simply, I was in communication with Advocate Profi, and he indicated that he wishes to bring an application, which I felt that it was pertinent that the court should hear that application first, and then once a decision has been taken on the points that he wishes to raise, we can then proceed to address the issue of whether my client is eligible to testify or not. So all the cards are in Advocate Profi's hands on this matter.
Yes. Okay. While the court is going to listen to you, it's very much proper that if you have got issues, I'm talking about all of you, please address those issues in writing in advance so that the other parties can also react to that. because now it appears now that the evidence leaders were trying to contact you. They couldn't get hold of you until they got a number, the number that they were given by Ms. Mokhosinyane. That's when they were able to get hold of you, when you told them that there is a possibility that you are going to address the court. And now when you come to court, you indicate that you had discussions with Mr. Profi.
My
You
lady, I don't
understand?
know. I do understand, my lady. However, I
Okay,
don't know
can
what
we
is
listen
saying.
to Mr. Profi? Mr. Profi, you may proceed.
But I might just get an indication from the court that the court can hear me.
Yes, I can hear you now.
But I'm not going to overextend the point, but my instructions are threefold. First, that this court is asked to record a finding as to whether the deaths were brought about by any act or omission involving or amounting to an offence on the part of any person. My lady, if I can then turn, my lady, to an exhibit that was part of the arbitration proceedings found on page 30396.
I'm listening, Mr. Profi.
My lady, I couldn't hear my lady there.
I'm listening. I hear you're quiet, so I want to hear what you want to say.
My lady, this I just want to place for the purpose of the record that this is.
You have just referred the court to the page. Is it 30396?
Correct, my lady. The heading of the document begins before the ad hoc tribunal in terms of section 88A1 of the National Healthcare Act 81 of 2003. Is my lady there? My lady,
yes, I'm there.
This is an appeal by Musecho Home and Takalani Home against certain findings and recommendations made by the ombuds. So I do not wish to take my lady through the entire decision before the former judge president. I wish to just take my lady to the findings there too, which reflect on page 30406. Is my lady there? May I continue? Ready for the purposes of the record, I just wish to read the page in that it says, to the extent to which the appeal succeeds, 22.2, findings in the first respondent's report in respect of the two appellants, which are contrary to paragraphs 22.2.1 to 22.2.4 below, are hereby set aside and substituted by the following. There is no conclusive evidence that mental care health users who will receive from Life Esidimeni Center, Musecho Home and Takalani Home under the Gauteng Department of Health Gauteng Mental Health Marathon Project, and who died at the two homes, died under unlawful circumstances. 22.2.2, Musecho Home and Takalani Home did at all relevant times operate with valid licenses. 22.2.3, Musecho Home and Takalani Home did at all relevant time have adequate infrastructure and facilities. 22.3.4, Musecho Home and Takalani Home that at all relevant times have professional staff. My lady, what I request from this court is that the commonality in the issues that relate to the issues of fact and law is clear. My lady is asked to make a finding, and this tribunal, chaired by the former judge president, made a decision and made a ruling in respect of the finding, my lady is also asked to make a finding too. Expecting Museko Home and Takalani Home to again fund and endure an inquiry into their conduct where a decision has already been made, the court should take consideration to the question of equity and fairness, and such expectation produces great hardship, and I submit even a positive injustice to both homes. Then, my lady, Section 34 of the Constitution states that anyone has a right to have a dispute resolved by the application of law, decided in a fair public hearing before a court, and where appropriate, another independent, impartial tribunal or forum. Maseko Home and Takalani have exercised such a right, and the decision was found to be in their favor. The extension of those findings that have already been made goes against their constitutional rights. Judicial certainty must be ensured sorry, my lady. Judicial certainty must be ensured, and further, we should prevent contrary conclusions on the same findings. The integrity of adjudicative functions of the court must be protected. Lady, I submitted the purpose of this once and for all rule dictates that the final judgment has been given in this regard. On the same set of facts, my lady is asked to make a same finding that has already been found in respect of the same subject matter should not be permissible. The object of the principle is that where a finding has been adjudicated to finality, a subsequent attempt to litigate the same finding should not be allowed. The underlying rationale to this principle is to ensure certainty of matters and that that matters reach finality and to prevent an abusive process. The present case before my lady and the previous case is based on the same set of facts, and my lady is asked to adjudicate on a matter that has already been adjudicated upon. My submission is then, in what regard is Museko Home and Takalani then expected to appear before this inquiry when they have a decision by the former judge president? The reason why I brought it before the current witnesses mean to testify is because if my lady sees that the finding has already been made, that there is then no need for further evidence to be presented by the next witness as well as the witnesses representing Mr. Home and Takalani. That is my submission in respect of the first fold of my submission. The second fold is let me pause there and I'll continue once the evidence leader has addressed the court.
Come again, the second one?
I'll address the second and third once the evidence leaders have addressed my lady.
Yeah. If I may, is it proper to deal with this thing in this manner?
My lady, I can't see why not, because the answer is quite straightforward.
Okay, no, that's fine. It's fine, but I just wanted to check if you will have an opportunity, all of you, to deal with what is being discussed now and the submissions made, taking into account that he's now saying that the evidence leaders must first say something and then he will deal with the rest of the other issues. But if you want to proceed, you may proceed. I just wanted to check, because remember, the other parties are also here. So it's not about the evidence leaders as if the evidence leaders are prosecutors in a trial. That's why I'm raising this. Yes, Mr. Late, you want to deal with the matter?
Yes, thank you, my lady. Firstly, it's quite disturbing that after such a long time, the people still do not understand that this is not a trial. Nobody is a defendant or an applicant or an accused in this matter. We are not prosecutors, we're not prosecuting anybody. Everybody are witnesses who testify in this matter. The matter that my learned friend referred to, the Museko Home and Takalani were the applicants. There are no Mosego Home and Takalani represented in this matter. A criminal court cannot find an entity like Takalani guilty, for instance, of murder. It must be a person. That's why an inquest deals with the question when any person can be responsible or can be held criminally responsible for the death of a person. The findings in that matter dealt with Takalani and dealt with Mosego. And it's further, my lady, known fact that similar circumstances, similar facts or same facts can lead to different legal processes. For instance, a person can be found not guilty of culpable homicide in a motor vehicle accident, for instance. But the family of that person who was killed can still, in a civil court, claim damages for the killing of that person. Out of the same set of facts, you get different judicial processes. And this is a totally different judicial process as the appeal was that my learned friend referred to. So I don't know why the people don't just go ahead and assist us and work with us, not against us. We are not different sides of a coin. We're not different sides of a court. We are here to assist this court in coming to a decision regarding the death of the people. Why everybody wants to take side roads all the time and want to work against us, I can't understand. We're just trying to get all the evidence before this court so that this court can in the end make a finding regarding the causes of death of all the deceased. So I'm asking the people with this in mind that we just go ahead and proceed and finalize this matter. When this court make a finding at the end of the matter, that finding is in any way not binding on any party. The final decision still lies with the Director of Public Prosecutions, no matter what this court finds in the end of the matter. As a court, please, Marie.
Just before you step down, I think, well, Mr. Prof will have to clarify me. I mean, that is just an application. It's not an arbitration. He referred to an arbitration. So, but what he referred to, yes, that was an application which was adjudicated by the former judge president. That's correct. So it shouldn't be confused with an arbitration.
Yes, but the document, the decision forms part of the evidence in the arbitration. Yes, that's right. It wasn't an arbitration, it was a mere application for the review, actually, of the Ombudsman's findings regarding Takalani and Mosego.
Thank you.
Thank you, Marlene.
I don't know if anybody wants to say something before I move back to Mr. Profi.
May it please the court, my lady.
Yes.
Sorry, my lady, I see Mr. van Bergen's, my colleague, his hand was up before I.
Okay, I didn't notice that. So maybe you prefer that I start with him. Okay, Mr. van Bergen.
My lady, I'm quite happy for Mr. Pienaar to proceed. He is my senior, so he's welcome to proceed.
Okay, Ms. Hasim, I've also noted you. You will come after Mr. van Bergen. Is there anyone else, as I'm recognizing Mr. Pienaar now? Okay, Mr. Pienaar.
May it please the court, my lady. My lady, I would respectfully submit that Mr. Profi's, our learned friend's objection, if it's an
You know,
objection.
just a
or
second, just a second. If I may, I'm worried. I don't know. Let me just find out if Mr. Pihlela, I think I forgot to ask Mr. Pihlela because I don't know whether he wants us to finish with this one and then he will address the court later. Mr. Pihlela?
May it please the court, my lady.
Did you say you wanted to make submissions after Mr. Profi, or you prefer that we finish these submissions by Mr. Profi and then you will address the court at a later stage? I don't want you to be coming with another application while we are done, or should we finish this one and then we'll later come to you?
Yeah, as it pleases, my lady, I think that would
No,
be...
I don't know what you want to tell the court, but whatever you want to say to is that interlinked with what Mr. Profi has said to the court?
Yes, on this aspect, my lady, it is interlinked. We can deal with this particular application, and then maybe afterwards, if there's a need, I'll address the court.
If there is a need, okay. Thank you.
Indeed, my lady. Please.
Okay, you may proceed, Mr. Pinar.
May it please the court, my lady. I'm indebted to your ladyship. My lady, I would submit that it would have been proper for our learned colleague, Mr. Profi, to have proceeded by way of a formal objection, if it's an objection, or if it's an application that he's intending to proceed with. It should have been done in a formal manner. And there are serious issues that are being raised, my lady, and that's with regard to the ambit of res judicata. The impression that I've gained at this stage, and from these submissions made by my learned friend, Mr. Late, is that this was a review matter in which the former Judge President delivered or handed down a judgment. And then the question that comes to the fore is whether that judgment was of such a nature that it resulted in the issues that it dealt with being res judicata or not, my lady. And without making a formal submission in this regard, my lady, but it does appear to me that the said review adjudication was more in a format of a decision handed down by a tribunal, my lady, which appears to have been administrative of nature. And then, of course, the promotion of the Administrative Justice Act comes into application and to the fore. And it's quite clear up until this stage that no further steps of whatsoever nature were taken in that regard with regard to the adjudication arrived at. I would submit, my lady, with all due respect to my learned friend, Mr. Profi, that this is a matter that should have been presented to this Honourable Inquest Court, which I do submit is not bound on the principles of res judicata to the decision arrived at by the Honourable Judge President, former Honourable Judge President, Mr. Mwepe, regarding the tribunal in which he had presided. Because clearly the provisions of the Inquest Act supersedes what the issues that had been adjudicated at that tribunal, my lady. This court, with all due respect, my lady, is not called upon to hand down a decision or adjudicate the issues in a matter called upon by that tribunal to adjudicate. The principles of the Inquest Act is quite clear, leaves no doubt. The issues differ in material respects from the issues dealt with by the said tribunal. And if that's the case, my lady, the res judicata is not going to be applicable, the principles of res judicata, and therefore this Honourable Inquest Court is not bound by any decision arrived at by the said tribunal, and therefore the inquest should be proceeded with, and the grounds forwarded on which the objection or application is founded is not substantiated, my lady, with all due respect. But to be fair to our learned friend, Mr. Profi, and I would suggest that this should have been presented to this Honourable Inquest Court by means of a formal application, or at least in a written objection for the other parties involved in this inquest that's been dealt with to respond thereto, in order to be of assistance to your ladyship in arriving at a fair and justified adjudication of the issue that has now been raised, my lady. Notwithstanding the fact, my lady, that my submission would be that the objection is unfounded and not substantiated in a manner as presented. At this stage, it's clearly an interlocutory matter, my lady. It would be within your ladyship's powers and authority, my lady, as the presiding official in this Honourable Inquest Court, to direct that a final decision will be handed down once this matter is being adjudicated, or at the final adjudication, my lady, seeing that it's an interlocutory issue that does not present or provide a final answer to the whether the inquest can continue or not, my lady. With all due respect, the inquest can continue, and should your ladyship, at the finalisation of this inquest, having heard argument on this issue, conclude that it's founded, then it can never inure to the detriment or prejudice of any of the parties involved, my lady, because then it would result in them being absolved. But to do it at this stage, my lady, in this manner, my submission is it's improper, and it can be dealt with validly by your ladyship once the evidence has been completed that's to be presented to your ladyship for purposes of this inquest, and when having heard formal submissions from all parties involved for your ladyship to make an adjudication or hand down and final adjudication in terms of section 16 of the Inquest Act, my lady. This issue that's been raised does not in any manner result in a final adjudication of this issue on this point, my lady, and therefore I would submit it would be proper for your ladyship to direct that the inquest continues as intended, and as your ladyship has indicated, with the assistance of the evidence leaders, who the next witnesses are to be called as indicated, and that this interlocutory matter be dealt with at the final stage of final adjudication of this inquest. May it please the court, my lady.
Thank you. Mr. van Bergen.
Thank you, my lady. I will be brief. Mr. Pienaar has covered what I wish to submit to your ladyship. In a nutshell, my submission is that your ladyship, sitting as a high court, is not bound by a decision of a statutory tribunal. Your ladyship, with all due respect, may proceed and may order that the witnesses, specifically Mavis Mokhosinyana, be called, and your ladyship can make a finding on the evidence in respect of section 16(2)(d) of the Act, irrespective of whatever the finding was made by the statutory tribunal presided by the former Judge President, as your ladyship pleases.
Thank you. Yes, Mr. Profi, I think before I go to Ms. I nearly forgot you, Ms. Sim. Thank you very much. You may proceed.
May it please the court, my lady. I also will be very brief because I agree with both my learned friends, Mr. Pienaar and Mr. van Berken. I think it is improper for this application to have been brought today at the last minute without any warning to any of the parties, and without a formal application that allows us to respond properly. But in any event, the decision of the internal appeal tribunal is a statutory tribunal, and it doesn't bind this court. And I would respectfully submit that we should continue with Ms. Mokhosinyana submitting evidence to the inquest. The inquest is aimed to get to the bottom of what happened, and this court can come to a decision based on the facts that are presented to this court. Thank you, my lady.
Thank you. Would you like to proceed, Mr. Profi, if there is no one making submissions? Just before, is that all from the submissions that we got? Yeah, you may proceed, Mr. Profi.
I'll first address the issue of timing. As all my colleagues in the court is aware, that the representatives for the two homes, we had the issue of legal representation. Once the attorney was on board, my lady, my lady is frozen on my end. I just want to ensure that I am heard. Am I the problem?
No, just proceed. I can hear you.
Okay, I just wanted to ensure because my lady is frozen on my end. Given that they didn't have legal representation, it was brought today because the next witness, which involves the two homes, is the next witness, and thus I only had last week to then take instruction in respect of, to consult and take instruction in respect of this. If they had legal representation sooner, I have no doubt that the application would be before the court sooner. It is the reality of which we find ourselves in, and I wanted to, instead of having evidence being led and bringing an application thereafter, sit in a position where the court asks me, why did we then have the witness give evidence if there was this looming issue in respect of if there is a need for this witness to give evidence, which is why it is brought today before the witness gives evidence and not when the representatives for the two homes would then give evidence. Right, in respect of the submissions made, that the issues are different, I respectfully disagree with my learned seniors that the issue was argued before the tribunal, the facts relevant were presented before the tribunal, and it made the former judge president made a decision in respect of the matter. The court is then going to make an identical finding in that respect. So the issues are not different, but I submit identical in legal nature. Then to address the evidence leader that we're two sides of a coin and that we're not fighting, I absolutely agree with the evidence leader, and that is the very foundation of this.
Just before you move to that, the two of your colleagues, Mr. Van Bergen and Mr. Well, even Ms. Hassim and Mr. Pinar, they submitted that this is a decision of a statutory body, a tribunal. What do you say regarding the status of this court sitting as the High Court in an inquest, right, as against that decision of the tribunal? Do you agree with the submissions made?
My lady, my submission is intertwined with what the evidence needed. Apologies for interrupting, my lady.
Yes, you haven't addressed the court in that regard. I want to hear your response to your reply to that.
My follow-up to that, my lady, is intertwined with what the evidence leader had concluded. He concluded that the evidence leader as well as the prosecuting authorities are not bound by this court and nor the decisions made in the tribunal. So my submission was in respect of that I agree with the evidence leader that we are all here to assist the court. And that is the reason why this decision was brought to the court, to say that to assist the court that a tribunal was already formed and sat and decided on this matter. And therefore, in facilitating the speedy resolution of this inquiry, what this inquiry is expected to do has already been done, and therefore is of assistance to this court. So it is not brought in light of opposition or resistance to the evidence leader wants to bring to the court, but merely to say that a tribunal has already been set forth, a decision has already been made, and therefore to ask this court.
What was the mandate of this tribunal?
It was an appeal.
According to you?
It was
because this was an application for the review of the proceedings of the ombudsman's decision, right?
Correct, my lady.
Yes, but what was it that these applicants wanted the tribunal to do, if you say these are the same issues?
So once the ombudsman's report was released, they took issue with, the issue was twofold. The generalization of implications on NGOs. So that issue would be, my lady would be familiar with that issue. It's in respect of when evidence is led in general of NGOs and conclusions were made of general statements that related to NGOs. They took issue with that those general statements are not applicable to the two homes, was the first issue they took. And then the second issue was that the findings that the ombudsman made in respect to their conduct, in respect to their license, in respect to their staff, and in respect to their infrastructure was wrong. And it was on that basis that the minister then appointed the tribunal, who then sat, the matter was argued, and the decision on those four aspects was then granted in favor of the home in respect of the deaths that occurred at the homes and the issues that I have said before, my lady.
Yes,
and
but my question is, you agree that that was not an inquest So when you say that the issues are the same, on what basis are you saying that? That is why I'm asking you that what was the mandate of the application? That application, what is it that it was to do? We understand that that was a review, right, of the decisions that were made, the findings in the report of the Ombudsman. Those decisions were they the decisions also from a statutory body, isn't it?
Correct, Madam.
Yes. Now my question is, you agree that this is an inquest?
Yes, Madam.
So on what basis do you say that what was done there, right? The issues that have been decided there are the same as the issues that are before this inquest?
In respect of the conduct was unlawful, we now know that the tribunal sat and went through and found that the conduct was not unlawful. So we now must sit and rehash all of that again.
Okay, continue.
So in respect of my submission that it is similar, it's similar in respect of the findings that this court has made, has already been made. The evidence
now
was
the further question is, which I haven't heard your response. It's whether that tribunal's findings, whether this court is bound by those findings.
Mary, I submitted in light of there being no appeal or no review to that decision that the court is bound, because we're going to sit and do the same thing again.
Okay,
for what purpose?
But now there is a concern now that this application that you are making should have been properly made, right? You haven't addressed it. That is why when you started, I asked whether is it proper to deal with it in this fashion, because the other parties haven't even responded.
My submission is in line with the previous submission I made, that this inquest is not sitting as an appeal or review court of that decision. So there's no need for my learned friends to comment on that decision, because then all of that turns this inquest into...
On which decision now?
On the former Judge President.
So there's no need for them to comment on your application. You come to court, you just, out of the blue, you haven't prepared them regarding this application, so they are not entitled to comment. Is that what you're saying?
They've made the necessary comments that they want to make, my lady, and I submit that if we extend the issue further to a written application, we are then taking the former Judge President's decision on appeal or review in an inquest.
But what are we doing now? What are you saying we're doing now? Because we are listening to your submissions. They have commented. So the issue of the appeal, where does it come from? Because whatever we're doing now, it's what you were supposed to have done, to bring a proper application before court, which they would be forewarned to know that today something was going to happen. Because all of them, they just came today not knowing what was going to happen, right? So you just caught them by surprise. That is exactly what they are saying, although some have commented. If you heard the argument of Mr. Pinar.
Correct, Malay, in that
But I don't understand now. You are talking about the appeal. I don't know what is it that you are saying. If you can explain to the court.
What I'm saying is that for us to argue the decision, we are then turning this inquest into the appeal of the former Judge President's decision, the decision by the tribunal. But my lady, my submission is
you have raised issues, right? Yes. Now your colleagues are saying you should have brought a proper application, because the way you have brought this application is improper, because they were not warned about what they were going to meet today.
So I remain with my submission that in the manner of the representatives not having legal representation, and my aim or goal was to bring the application formally before they were to give testimony. However, in light of the sequence of events being that the next witness is an employee to Masego Home. I did not want the evidence to be led and then a formal application to be brought subsequent to her evidence when this application impacts and affects her testimony. It's why today was my only option to bring it. But if the court wants there to be a formal application, my submission is then that we stand down the witness's evidence and that the application be dealt with in the manner in which my learned friends desire, and then the court makes a decision, and then we proceed. We'll then know if it's necessary for the representatives to give evidence as well.
I've noted you, Mr. Pina. Yes.
As well as
Mr. Prof.
That is my submission. We then stand down, do this witness's evidence, which it then relates to the second, if I may now take this opportunity to then address the court in respect of when I said my second submission, is that the next witness.
Just before you go there, let me hear what Mr. Late wanted to say. Mr. Late?
My lady, although I agree that a formal application would have been advisable, I think in view of what was said today, the issue is quite clear that this court is sitting as an inquest court and the witness is a witness in an inquest. I would submit that it's not necessary to take this whole matter to a formal basis at this stage. It's my submission that the finding by this court is quite obvious, and so that it can arrange for the witnesses to come and testify and get finalization of this inquest. It's clear that Mr. Profi has taken different matters or different kind of matters and threw them into one bowl, and he can't say at this stage what he actually wants with his application. Does he want this to have the witnesses excused because they have already testified in another matter? What is the purpose of this application? Because even if that application, the witnesses or those findings can be applicable to the inquest, there's nothing that says that the witness cannot be obliged to testify in this inquest. And to the contrary, the Inquest Act, read with the Criminal Procedure Act, says that the witness is compelled to testify if subpoenaed in an inquest. So whatever he wants with this application, it's not going to make any difference to the inquest. As a court,
just a second, I'm so concerned as to the manner in which the application is being brought, because now he's throwing something, he wants the court to make a ruling. Everybody must now argue, whoever wants to respond to the submissions he has made. Now we must move to certain points, because now, isn't it, he argued the first point. Now, before he goes to the other points, he says, let me hear what the evidence leader is going to say, right? From there, now he wants to bring the other. That is why I'm saying he should have just brought a formal application so that we can know exactly what he wants. We shouldn't deal with the application piecemeal.
That I understand, my lady, but
yes.
As regards to the status of that exhibit, I think that is quite clear in legal terms. As I had said, the witnesses that testifies in this inquest wasn't part of that application. Those were the applications of Takalani Home and Masego Home, which were applicants. Furthermore, as my learned friends Pinar and Van Bergen and Hasim stated, the status of that application is the status of a statutory body, and this court is not bound to anything that was done in a statutory body. So the decision regarding the status of that judgment is quite clear, and I think the court can at this stage already make a judgment in that regard. That's my submission, my lady. What is other applications or other requests will be, I don't know. As my learned friend stated, we could have at least been informed of what they planned. The evidence leaders could at least have been informed what they planned, so that we can make our plans for the continuation of leading the evidence. That's a call, please, my lady.
Thank you. Mr. Pichela, I've noted you.
Sorry, my lady, to interrupt, but you appear to be frozen. I'm not sure whether it's only on
Am
my
I?
side.
Can you hear me?
Can hear you, my lady. Yes, that's how
Yes, so I'm not frozen.
But I don't see any movement when you're talking, my lady.
Oh,
That's
okay. All right.
Your picture is frozen, that's all.
You see any movement now?
No, my lady.
No,
Okay,
my
but
lady.
you can hear me clearly, ne?
Can hear you clearly, my lady. That's correct. I just thought
Okay,
I would
that's
mention that, my lady.
Okay, thank you. Mr. Pichela?
Thank you, my lady, for court, please. The court will correct me. I understand that prior to us, myself in particular, coming on record, this court has accepted the arbitration record as being part of the proceedings. And I presume that this court has also accepted the Ombudsman's report or as part of these proceedings as well. Now, my understanding of the issue being raised by Advocate Prof is that on the issue of whether these witnesses are eligible to testify, now that is within the court to decide. But we are merely duplicating a process that has already been looked at by the Judge President or then Judge President. And at the end of the day, whatever decision that this court is going to make is going to coincide. Either this court will have to confirm that indeed there was no wrongdoing, or eventually it will have to say that there was wrongdoing. And in so doing, it will then be, in a manner of speaking, overruling what has been done by the Judge President. I've heard we are speaking about whether the court is bound by that decision of the tribunal or not.
Yes.
And my submission in this regard is looking at the objectives of this inquest and what this inquest seeks to achieve. I would submit humbly that it is not for us to traverse processes that have already been traversed by other tribunals. If there's been findings that are made and decisions that are taken, then duplicating those processes indirectly in this manner, it's merely a waste of time.
In what respect, Mr. Pichela?
If I may say that, my lady. Because if this witness is coming, then we need to know what value the witness is going to add on top of all the evidence.
Yes, but okay,
Pardon,
I want to. Okay, just finish, and then I'll just leave Mr. Lee to say something maybe before I get in now, because I understand that decision differently. Yes. Okay. Continue.
Yes. Hence, I indicated that I speak under correction, my lady. Now, just to surmise, my lady, my submission would be that in this instance, it is important to know with each witness that is being called what that witness is being value they bring to the proceedings. As the court has indicated, and as your ladyship, as Advocate Late has indicated, this is not a criminal trial.
Correct.
So it does not follow that each and every witness whose statement is on record should be called in. We need to understand for what purpose is that witness called, in order for us also to also prepare those witnesses, my lady, because if the witness is being called to come and confirm their statements that are already being admitted, then I'll submit, my lady, that we are simply duplicating processes. But if witnesses are being called on aspects which need answers, then that is a new direction that we can follow. And that is my submission, my lady.
Thank you.
May it please the court.
Mr. Late.
Thank you, my lady. Firstly, I agree with Mr. Pishlela that when a witness has nothing more to add, that what is stated in his statement, it's not necessary for such a witness to be called. But as far as the NGO owners, as well as the members of the government are concerned, it is clear that their statements are mere statements that gives a broad overview of what had happened. We did
You
not
say, just a second, you say it is clear that the statements are not clear.
Yeah, it doesn't go to the detail of each of the deceased who had died, exactly what had happened. That is why the witnesses are called. It's just like as in a criminal trial, the statement of a witness is not a complete version of what he can tell the court. That is why some of the witnesses are called, because it is suspected that they can tell the court more. Where I differ from Mr. Pishlela is regarding the so-called duplication. What the tribunal did was found that no wrongdoing in general can be found with regards to the two NGOs. But that is not what this court is called for, whether any of the NGOs was involved in wrongdoing, or whether any of the government officials was involved in wrongdoing as such. This court must make a specific finding whether that wrongdoing was responsible, criminally responsible for the death of a deceased. That is why from the start, I asked the people, all my colleagues, to concentrate on causation, because it's there's prima facie evidence that there were wrongdoing on the part of a lot of the people. But whether that had caused the death of specific deceased, that is the question that this court must answer. That is why I say that the review did not deal with specific deceased, and that is what this court is called for to do, to deal with specific deceased and their causes of death. So that is why it's not a duplication of what was already done. This court has a specific duty to deal with specific aspects.
Thank you. Yes, Ms. Hassim.
My lady, I'm sorry to intervene. It's partly in response to Mr. Pitlela's submissions, but I'd like to agree with Mr. Late and point out to your ladyship that there are 25 of the deceased who passed on at Mosego home. And the implication of the application brought by Mr. Profi is that the people who were either present or in charge of the NGO should not testify. If that's the case, it will make it impossible for this court to interrogate the circumstances of the deaths of 25 of the deceased in the inquest.
Okay.
Thank you, my lady.
Mr. Profi, do you want to proceed with the next 2 points?
My lady, I just want to it's that my lady is frozen on my end,
Yes,
so
come again.
My lady is frozen on my end, so it's difficult to get direction from the court. If my lady could just repeat that.
Yes, can you hear me now?
I can hear my lady, but
Yes, I'm asking whether you'd like to proceed with all your points so that the court can deal with them at once.
My lady, I think it's fair that to first get a ruling in respect of this, and then I'll make my second and third thereafter. Because it's dependent on my lady's ruling.
Okay, that's fine. It's now 11:05. We can resume at 11:20. And then the court can take. Okay, Mr. Bihlela, you want to say something?
No, apologies for interrupting, my lady. I thought your ladyship was done.
Can we take a tea adjournment now, and then we resume at 11:20?
May it please the court, my lady.
As the court pleases, my lady.
As your ladyship pleases.
God pleases.
Easy, my lady.
Okay.
We can hear you, my lady. We are here.
Okay, thank you.
May it please the court, my lady.
The court makes the following ruling. The review was heard by a tribunal in terms of Section 88, capital A, subsection 1 of the National Health Act 61 of 2003. This was in respect of specific legislation. The proceedings before me are an inquest court, and the purpose thereof, as outlined in Section 16(2)(d), is to determine the cause of death of all the deceased in this matter and to make a finding whether there should be any criminal prosecution of any person resulting from the deaths. So this was not the task of the tribunal to investigate and inquire into the cause of death and further answer to the questions as listed in Section 16(2)(d). The ombuds did not investigate the cause of death. What was investigated was the complaints relating to the health norms and standards. On that basis, this inquest is therefore not bound by the findings of the tribunal that dealt with the review application. This is in relation to the concerns or the issues that were raised by Mr. Profi. With regard to those that were raised by Mr. Pitlela, the court rules as follows. The court has the right to call witnesses to assist it to come to a just finding. These witnesses are not the evidence leaders' witnesses, they are the court's witnesses. The witnesses that have been called to testify, they have been called on the basis of the statements that they have made, so that their veracity can be tested under cross-examination. Therefore, those witnesses do not have the right to refuse to testify. The right that they have is to refuse to answer questions which will incriminate them. So on that basis, the inquest has to proceed. Arrangements should be made for the evidence of Ms. Mokhosinyane to be led as soon as possible, and so that we can then proceed with the inquest. Thank you.
Yes, the court,
May it please the court, my lady.
Is your ladyship pleases?
Yes.
As the court pleases.
As the court pleases, my lady.
As the court
Yes,
pleases.
Mr. Profi, you want to continue?
Please, my lady. My lady, it's very briefly, the second submission I then make is in respect of the sequence of the witnesses. If
The sequence
in light
of
of
witnesses.
in light of my lady's ruling, the submission is that given that the two representatives for Mosego and Takalani is going to testify, that they give their evidence first to give the entire picture holistically, and then Mavis then gives testimony thereafter should the need arise for her to supplement. I do not want to step on the toes of Mr. Pashele being the one representing her, but I just think that in terms of how the evidence is laid, for the sake of the record and fairness to all the witnesses, that we don't put the cart before the horse in terms of hearing the evidence in respect of the witnesses to come, that we don't hear evidence in isolation and the evidence leader suffers the consequence of what he suffered when he called Daphne Ndlovu, being that he thought her evidence would be helpful, but turned out it wasn't. So just to avoid that repetition, that the representatives for the NGOs testify first. They could, in all purposes, canvass the evidence leader wishes to get from the witness to follow. And if that doesn't happen, then the witness can give whatever testimony needs to be supplemented to what is already given by the representatives of the NGOs.
let me check if I understand you before you stop. Are you referring to the whole list of witnesses that are going to be called, or particularly when okay.
Correct, madam.
Okay. Can I hear the evidence leaders? But before we do that, is that your last point, or do you have another point, Mr. Profi?
But my last point is, I don't want to somewhat phrase it as a point.
Can we just include it so that we can deal with it at once?
For the purposes of preparation for the two NGOs, the application made by my senior, Mr. Pinar, in respect of the arbitration, can I refer to the arbitration or not? Just so that I don't prepare on it and then my lady makes a ruling.
You want to know what?
In respect of Mr. Pinar's application in relation to the arbitration record, if we can refer to it or not.
Okay. Yes, Mr. Pinar. Not Mr. Pinar, Mr. Late.
My lady, as far as sequence of witnesses are concerned, is concerned, it was planned that all the witnesses who are not suspects or possible suspects in the matter testify first, so that the possible suspects can answer to their testimony.
Yes.
But I, as in principle, doesn't have a big problem with that. Because any of
that
the
is in the court's discretion in any event. These are the court's witnesses, isn't it?
It's in the court's discretion. Or I would submit then, if it goes like that, then I will request that Dr. Sikakune and I can't pronounce the surname of Musego's owners.
Is that Miss Mogojwa? Yes.
That they then testify first, followed by Mavis Mogotswane, who is Mr. Pishlela's client.
Followed by Mr. Pishlela's client. Remember, we take into account that I think both of them have just got legal representation, and we don't know how far are they with their preparations.
Yes, Mr. Profi can help us with that because he's the person who brought the application.
Okay,
he's the person
we'll look at that. He will reply. We'll hear when he'll deal with this in his reply. Then the second point regarding the arbitration, that ruling with regard to the issues that were raised to, he wants to know as to whether they have to refer to the arbitration. But the court will deal with it because I've indicated that as we started, we must just proceed on the basis that, isn't it, everyone has been proceeding. But I see, Mr. Pihlela, let me finish this point. Everyone has been proceeding as we have proceeded, referring to the arbitration record, because the court has indicated that this is, it will deal with the issues at the end once it has had the evidence in the entire inquest.
As the court is, it's correct that at this stage, the initial decision by the court was to accept the arbitration record as a part of the evidence, and that is still the situation until the court finds otherwise.
Yes.
I don't have any problem with referring to the arbitration record.
Okay. Mr. Pihlela, I've noted you, and then anyone who wants to say something before I close the matter. Mr. Pihlela?
Thank you, my lady. My lady, I wanted to accord with what Advocate Profi was suggesting with reference to Ms. Mogosinyane testifying after the directors of the NGO. With reference to the arbitration record, my lady, it would have assisted us in preparation, bearing in mind that one is representing 5 people in this matter, to know the status of the arbitration, because it impacts on the amount of preparation that has to go in place. But I can request, my lady, that if your ladyship deems it meet, maybe we get an indication from the evidence leaders with reference to all the evidence that has already been put forward, or on which aspects they would require some of the witnesses to testify, and also a calendar as to when, because one is no longer located in Pretoria, but in Benoni, and as such, it poses a logistical challenge to be able to meet with some of the witnesses and prepare them. So if one had advance notification of when a particular witness would be required, then perhaps one can work around that, my lady. May it please you.
Thank you. Mr. Late?
My lady, I cannot give dates when certain witnesses will testify. This court has experienced numerous difficulties in this. I have provided everybody, and it's part of case lines, the sequential list of witnesses. I plan to call the witnesses in that sequence, except when something like this now happens, when the sequence has to change. Otherwise, I cannot give possible dates when a witness will testify. That's totally impossible.
Yes, but what you can agree upon is that this is going to be, maybe this witness is going to start first before the others, so that if you can give us an idea, as we did previously, although the issue of the dates. Yeah.
Yes, that is why we have the sequential list of witnesses, which is part of case lines, my lady. Everybody has access there to and can see. But now this application now came from Mr. Profi that Dr. Sekukune and Mr. Mokhchani getuig first.
Yes, but the court still has to rule on that. It is the court's,
yes, otherwise,
discretion.
If the court doesn't change the sequence will be as it is on the sequential list of witnesses.
Yes. Can I hear anybody else before I close the matter?
Another thing, my lady, sorry, we still don't know what Mr. Pishlela's situation with Ethel Bube is. If he can maybe give us an indication whether he's going to, or whether anybody is going to represent her.
Yes, that was the issue that I wanted to also deal with. Mr. Pishela?
There are 2 witnesses who will have to be recalled.
Yes, Dr. Talatala and Nofile.
Yes.
Mr. Pishela?
Yes, court pleases, my lady. I did indicate via email to Nelisiwe that I am back on record for Ms. Ngube. Those were the instructions.
I must confirm that I received that email late. I don't know whether you didn't send the email to the others, but I received it, I think, on Friday.
Yeah, I responded to it the same day that I got it, my lady. I just replied on it.
Okay.
Yes, court, please.
So you are back on record on behalf of, so you can discuss with Mr. Late as to when the witnesses will be ready. But we must be mindful of the time, because we had about 1.5 weeks, which we could have utilized. So
I agree.
And it appears that Mr. Pishela has been busy with his relocation issues. So I don't know what was going to happen if the matter proceeded, because now it appears that he's talking about he's moving from one office to another. So you'll have to make sure that you consult with the witnesses. Yes, can we deal with those 2 issues so that the court can make a ruling with regard to the sequence of the witnesses?
If that
is necessary.
Back on record, if Mr. Pishlela has a background record, I would submit that we first call either Dr. Talatala and Mr. or Mr. Nufile, and that they should be finalized before we go to the next witness.
Okay, that's fine, but I will want, the court will have to deal with the request by Mr. Profi. I just want to hear the others. I only heard the evidence leader and Mr. Pishlela. Anyone, if anyone wants to say something with regard to that and the issue of this arbitration, this ruling regarding the arbitration. It appears, okay, Mr. Pina.
Lady, with all due respect, my lady, to my learned friend, Mr. Profi, your ladyship has made a ruling in this regard, my lady.
Yes.
And the ruling is still applicable and applies until the matter reaches finalization, my lady. And
Yes.
your lady hands down your final adjudication in this regard, my lady. And
Okay.
I would submit it would be proper for this Honourable Inquest Court to continue in accordance with the adjudication handed down by your ladyship, my lady.
Okay. Thank you very much.
Report.
With regard to the first issue of witnesses, there is a request. I don't know whether there is a request here that Ms. Mokhosinyane should testify before Dr. Sikukuni and Ms. Mokhojwa. Okay.
After, my lady, after.
Can I deal with the matter? What do you want to say, Mr. Pishlela? I think you have already eaten your cake.
Yes, apologies for budging it. I was saying after. I had your ladyship saying before.
Okay,
so
after.
I think
Yes. Okay, that's fine. Yes, after. Yes. With regard to the issue of that pertained to the issues that were raised by Mr. Pinar in the arbitration, which pertained to the arbitration record, its admissibility. The court has long indicated that the issues raised there will be dealt with the evidence in its entirety at the end when it deals with the evidence on record in the inquest. And then the request here by Mr. Profi regarding the sequence of witnesses. I just want to indicate that we must understand that it is the court that have called these witnesses, and the court saw it fit that witnesses who are not implicated or who are not interested parties were the witnesses who were first required to testify. Some of them, like for instance, the NGOs and the government employees, the three government employees have been put towards the end of this hearing. So I don't see any reason why the list should be adjusted now so that these two owners of the NGOs, Mosego and Takalani, should testify before the witness, Ms. Mokhosinyane, because whatever evidence that will be there, they should be able to get an opportunity to deal with it if they are implicated in that evidence, because we don't know what Ms. Mokhosinyane is going to say regarding these two NGOs. So in my view, it would be preferable that Ms. Mokhosinyane testifies first before the two owners of the NGOs, Dr. Sikukuni and Ms. Mokhosinyane. So arrangements will be made that these witnesses continue in the sequence in which they were. Remember that Ms. Mokhosinyan was supposed to have testified long ago, even before the doctors could testify. I hope I'm clear.
As the court pleases.
As the court pleases.
So arrangements will first be made now for the evidence of, I think, those two witnesses who are supposed to be cross-examined by Mr. Pihlela. And after that, Ms. Mokhosinyan will have to follow. Then we'll then proceed as such. Then arrangements can be made in that regard. Thank you.
As the court pleases. My lady, I don't know if this, my lady had asked me a question in respect of how far my preparation is for the two NGOs.
Yes.
My lady,
in fact, I was not asking you, I was just noting, just mentioning it, because okay. I was asking myself that if, that is why when you were addressing the court, I was asking myself as to whether you will be in a position to do justice to your witnesses if you the two clients of yours. So I don't know how far you are with your consultation with them, taking into account that. But the fact of the matter is that they have been part of these proceedings, and luckily you have also been part of the proceedings. So it's unlike somebody who's new in the proceedings, and I hope that is not going to delay us.
If I may, my lady, thank you for the concern, and I do express the same concern. I don't mean to turn this platform into a case management, but I merely am asking from the evidence leader from the perspective of delaying. What I'd like to avoid is that, given that my learned colleague, Mr. Pishela, is recalling witnesses, for me then not to have to recall that witness again, that between myself, the evidence leader, and Mr. Pishela, if we can just put our heads together, that when we call the witness, and there's a need for both parties to cross-examine, that we do so, and not Mr. Priscilla cross-examine now and then the witness has to come again for me. So
yes, you are raising a valid point in case you feel that you need to deal with the evidence that was left unchallenged. Correct, those witnesses, but you can just indicate, you talk to the evidence leaders so that by the time we go to your client's evidence, that shall have been done.
As the court pleases.
Okay. Mr. Late.
Thank you, my lady. I've just contacted the investigating officer. He cannot get hold of the fillet at this stage. He tried immediately, but I'll keep on trying. I'll contact Ms. Stevenson regarding Dr. Talatala, when and whether he will be available in this week to testify. But I'll try my best to get hold of them both before going on to the rest of the witnesses.
Mr. Profi is raising another valid point with regard to him having to cross-examine the witnesses that have already testified. I don't know, he will talk to you which ones, but whether he will like, whether there are those that he can recall. I don't know, we'll have to check, you'll have to check with him.
Yes, he's just
if that will be necessary.
Yeah, from the top of my head, there were no witnesses that actually implicated any of those people, but you can have a look and we'll discuss that.
Yes, but he can discuss that with you, and then I'm going to adjourn the proceedings, and I don't know what should happen now, because you can't give us an answer. In particular, Nofile will be testifying about precious angels.
Precious angels, that's correct.
Yes, and then Dr. Talatala also. Come again?
It's just for cross-examination by Mr. Pihlela.
Yes,
and Dr.
Even
Talatala
Dr. Talatala.
Also for cross-examination by Mr. Pihlela, yes.
I just don't, I want us to have, well, we can start with Mr. Nofile. I want us to avoid a situation where we will call a witness, and then after he had left, then Mr. Profi will come and say, I also want to cross-examine that witness. Now that he's fully on record on behalf of these two NGOs.
Yes.
Yes.
So I'll try to get these two. That's Nofile as well as Dr. Talatala. In the meantime,
but just find out, I don't know, you can check with him if in case of Dr. Talatala, will he have questions, or whether he's ready to cross-examine him in case he feels that he has got questions.
Yes, yeah. I'll ask him to prepare so long for Dr. Talatala. I presume Dr. Talatala will not be available on short notice, but I'll speak with Mr. Stevenson.
So I don't know.
But I'll send an email.
Do we adjourn until tomorrow morning, or what is the situation?
I think so. I think we can adjourn till tomorrow morning. I'll send
if
an
there
email.
is anything, we will be notified.
I'll send an email, my lady, yes.
Okay. I hope that is the feeling of everyone.
May it please the court, my lady, I think that I would submit that such a ruling would be convenient at this stage, and hopefully we'll have the necessary clarification by tomorrow morning when we commence to proceed, my lady.
Okay.
May it please the court, my lady.
Thank you.
No objection, my lady.
Thank you.
Court, please.
The proceedings are therefore adjourned to tomorrow morning, so that we can hear what next could be done as to whether Mr. Nofile is available for the cross-examination by Mr. Pichela. Thank you. The proceedings are adjourned.
As the court pleases.
Court pleases.
As the court pleases, my lady.
May it please the court,
pleases.
my lady. That will then be 10 May 2022.